You mentioned earlier, I guess I want to go back to something you mentioned a little earlier. You were talking about warrants and probable cause. So let me just make sure, let me ask you specifically, when is a warrant required and what is probable cause?
Very difficult questions about when warrants are required. Warrants are required when you can get one. In a way, that seems like a smart alecky way of dealing with the answer, but there are a number of exceptions to warrant requirements. If you're in a situation where there are what we call exigent circumstances, where you've got to just go find the stuff very, very quickly, you may not necessarily need a warrant. If it is a search that is incident to an arrest, you may not necessarily need a warrant. So in those particular circumstances, there are some situations where you don't need warrants. But in circumstances where you do need a warrant, you've got to have probable cause. And indeed, even in some of those other situations, you have to have probable cause. Probable cause is not absolute certainty. It's a reasonable notion that you're probably going to find what you're looking for. A reasonable probability that you're going to be searching for stuff that you're going to find. You don't have to be absolutely certain, but it's not just a general hunch. It's something in between. Where is the in between? We're not absolutely sure. Courts tend to talk about probable cause and they'll evaluate whether a particular officer had probable cause, but they won't necessarily be able to tell you exactly what probable cause is.
You mentioned exigent circumstances and other reasons that will permit searches or seizures without a warrant. Do you think that this is a problem? Should we think it's a problem? And if you do, are there certain remedies you would suggest?
What we have to think about moving forward in terms of search and seizure law is what qualifies as a search, one, and number two, how much of our privacy are we willing to give up? So let's give the example that pops up a lot in the news, and that's the stop and frisk situation. Stop and frisk situation, been around for a long time, where an officer stops an individual, talks to them, recognizing that officers can stop individuals and talk to them all the time, but then also frisks them. The idea behind the frisk is the officer needs to be able to make sure that he's protected from any weapons that the person he's talking to may well have. Well, the question that pops up, or a question that pops up, is when is that used just as a way to see what someone happens to have on them versus when is that a legitimate law enforcement tool? How that circumstance is dealt with, which is inside of the Fourth Amendment and outside of the Fourth Amendment in some respects. Inside of the Fourth Amendment because it actually is a search, outside of the Fourth Amendment because it doesn't require a warrant or probable cause. That gets at the issue of how far are we willing to allow officers to go in gathering information in a circumstance where we think that we ought to be secure in our persons. So moving forward, we're going to have to ask some difficult questions about how far we as a society are willing to go in order to allow law enforcement officers to do the kind of crime fighting and the kind of information gathering that the Fourth Amendment allows, but only under certain circumstances.